Hey everyone, and welcome. We're happy to be here today for our premiere episode of our Crushing Land series. We're happy for all of you that have joined us either on our Facebook group, those of you who are in our YouTube channel as well. And so we want to thank you for joining us and for being part of this today. So what is the Crushing Land series? What are we talking about today? Well, basically, it's taking land to a whole nother level, right? We're here in the Land Method Group. What we do is we offer training. We're real estate investors. We do all these different things with land. We show you the training on how to do that. But inevitably, there's different things that we're going to run into with these, with different things that we're facing. So, for example, what we're talking about today is probate. Now, probate issues come up a lot when it comes to land issues. And we have them come up at least a few times a year. And the bottom line is that we're not equipped to handle that ourselves. We're not attorneys. We're not people that can go in and handle these things, but there are little things that we can do to be able to handle that and then hand it off to the correct professionals, right? And so that's what we're here to talk about today. That's what this entire series is going to be about. It's going to be about these different interactions, these different professionals that we work with, these different relationships that we have, things like that, that help us bring our businesses to the next level, to be able to tackle these different types of deals and be able to continue to grow our business while doing so. So I'm happy to introduce Al Nicoletti today. He is a real estate attorney. He specializes in probate, and he's going to talk to us about that for a while. You're welcome to ask questions. Feel free to put them into the comments below. And as you do that, we'll be able to, we'll be able to see them. I'll throw some of those questions at him as he's going along. So let him go through his presentation. I'll be talking a little bit throughout that myself with him and things like that, but we'll let him kind of give his whole spiel with that. We're happy that he's here. We've actually already had a couple people that have gone through our training use his services to be able to get deals done. Maybe he'll talk about that a little bit as well as he's going along. So we're going to let him jump right into it now. So let's welcome Al and let him talk to us a little bit about probate and the potential that it offers us to it. So here it is, Crushing Land, Crushing Probate with Al Nicoletti.
Jonathan, thank you so much for that introduction, and I'm honored to be your first episode on Crushing Land. I know we had the other masterclass before, and I think the topic blew everybody's mind. And every time I talk about it, there's always a new twist, a little tip, a little trick that somebody could do differently. And learning about probate is key because you come across it in all your deals. You don't want to pass it off if you know you can make money on the deal. And all really probate is just another puzzle with the real estate transaction. So again, honored to be here. I'm going to make sure I share this PowerPoint when we go through it. So we'll go full screen on everybody. Let's get from this start so everybody can see this. So right here, Crushing Probate, the first episode of the Crushing Land series. You can find my phone number and my email address on the bottom. So if you had to get in touch with me, that's where to find me. Of course, I have my website, www.alnicoletti.com. You can go on the website and you'll find all the services. You'll see my pretty smile there. You'll see the show that pops up when you immediately go on the website and all the other things that I provide with the legal services on my website. So check it out. You can find me on basically, I think it's now every single social media app except TikTok. I'm not on TikTok yet. So you can find me on Facebook. You can find me on Instagram, YouTube. I have a YouTube channel. I got videos we post weekly, and there's other content. So I'll have my show that I have, the podcast, and all the other micro content that I'm on the golf course. I'm walking and talking. I'm doing just tons of things on probate, partitions, quiet title, different weird things in the real estate world. So check it out. All the micro content on there. And of course, you have to make sure you check this out. The Al Nicoletti Show, which is every Wednesday at 8 p.m. I interview big time people in Florida. I focus in Florida that are real estate super investors, rising rock stars, movers and shakers, and people in our community that are absolutely killing it, and how they're doing it and what's their specialty and the value that they bring in the community. So make sure you check it out. All you got to do is you got to go to iTunes and Spotify, literally type in the Al Nicoletti Show. You'll see all the episodes. I think there's about like 20 to 25 so far, and hit subscribe, and there's more coming. It's not going to stop. It's going to keep on going. So of course, I'm a lawyer. I got to put my disclaimer out there. This PowerPoint presentation does not provide legal advice, nor does it provide any attorney-client relationship. The matters discussed in this presentation are educational and informational only. I love it, and it's all information. It's what I bring to this whole thing is education and fun. So I hope that it's educational and fun for you. So of course, what are we talking about today? Probate, 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 probate. We're going to nail this probate down to not only the basics, but all you really need to know. When it comes to probate, you don't have to know everything. And I'll make sure you understand that if you get the basics, you're good to go. You know where to go. You know what timing looks like. You've heard enough of the stories to know that you can do it yourselves with working with the attorney that does it. So we're going to talk about probate at length today. And a big question that always comes up with probate is, what is probate and why is probate? So it's not just what it is, but why it has to happen. And the why is important for you. So anything I'm telling is not the impressive nature of Al Nicoletti that he knows a lot about probate. That's great. But what I try to do is explain it so you understand, so that when you're in the field, you're even explaining it to some of these sellers. Because at the end of the day, it's not just me selling, it's you selling. It's you selling what you're trying to help the person achieve. So if you understand what's going on and you come off as confident, it's great. So what is probate? Somebody owned real estate. We'll talk about land, real estate, talk about that, but just know the basic concept. Somebody owns real estate. It could be a car, it could be a bank account, it could be a house, land, it could be something with title, and they own it in their name, not in an LLC and not in a trust, none of that, just in their name. And there's no special deed, there's no power of the payable on death beneficiary, there's nothing transferring it at all. They die. And in order for the heirs, whoever they are, if there's a will, what's in the will? If there's a spouse and there's children, who are they? If there's none of those, we'll go through the line. We'll do the whole probate Macarena that I have. But whoever's next in line, in order for them to sell, convey, mortgage, do whatever they want to do with the property, there has to be a process, and that's in court. It's called probate. And all probate is doing is moving the title over, transferring it over to the heirs. So then they have authority then to sell the property, whether it's real estate, land, personal property, car, or to get the money out of the accounts. That's it. Moving it over, the end. Distributing. Now that they have it, they can sell the property, they can do whatever. And the why, when it comes to probate, why do we need to do this? Well, in Florida, I'm not talking Texas, I'm not talking North Carolina. In Florida, especially, title insurance requires there to be the probate process because they don't want to take the risk on anybody coming back. It's all about risk and money. They don't want somebody making a claim later, so then they have to pay out to that person whatever that insurance policy was. So you have different states, like Texas has that affidavit of heirs if it's simple. I think North Carolina, I've heard where if it's after 2 years, you could do that affidavit of heirs thing. Every state's different, but with Florida, if you're in Florida, when you explain this to a seller and they're like, why do we have to do this? Why are we always doing this probate thing? I thought we totally avoided it when I recorded the deed and when I did this and that. Why do I have a will? You still have to go through it because title insurance wants you to. So just know that you can't quit claim it before probate. So when they try to do a deed before probate's done, you can't do it. Like I had a call the other day where the lady dies in 2010 and there's 4 children, no spouse, 4 children, and all of them, the 3 of them did a quick claim to one of them. Probate was never done. Fast forward 11 years later, somebody wants to buy the house. So they approached the lady, they brought the contract to the title company, and title said, you got to do probate. And she was like, why? We did a quick claim deed. Well, it wasn't done before probate. So there really wasn't a true transfer to the heirs. So now they sell. So Really big that you understand title insurance. Also, huge, huge. You don't have to know everything. I had a phone call this morning with somebody that said that they tried to look up like what probate was, and they read a book, and I said, no, none of that. I don't do that. If you read these books and you watch these videos, like these long tutorials, it's complicated, and you don't even need to use a lot of those words. Now, other jurisdictions may have different rules. It may be way more wacky and complicated in California and Texas than it is in Florida. But when it comes to probate and why you shouldn't pass it off as an amazing deal is because you don't have to be a probate expert. You don't have to know words like inventory and accounting and statement regarding creditors. You don't have to know all that. We don't even have to get into all of that all the time. So you don't have to know, you don't have to worry about technical aspects or complicated words. Just know it's a process, know where the title company is, know where the lawyer is, and know what you got to get up front. And eventually, what I'm going to do is I'm making a checklist, and I'm going to put it on my website. And it's going to be like one of those type form checklists. So if you're in Florida and you got that kind of lead and you're just like, I have no idea what to ask, where to go, that checklist is a basic form you can fill out so you can ask the right questions. It looks impressive. Building it out, it's not out yet, but the checklist is on its way. So what is that checklist basically going to have? One of the big questions you have to ask is, this is no different than any real estate deal you work on. It's and actually I heard it the other day. I was very surprised. Somebody turned in a contract to a title company, and the title company came back and said, it's the P word, the P word, the P word. I'm like, what's the P word? Like what? And they said probate. I'm like, so we're calling it the P word now? Like I that was the first time I ever heard of the P word before. And so don't be alarmed when you see probate. It's just a puzzle, right? You have puzzles at home, puzzles you've worked on. It's no different. You just got to figure out the pieces. So don't immediately see the P word and run away. So ask these questions. Number one, who are you even talking to? Do you even know who you're talking to? You have to, is this like, what's their name? Who are they? If somebody's deceased, what is their relation to that person? So if you know that Mary Smith died and she owned that property, but she died, no probate's ever been done, and you're talking to John, and John says, I'm a cousin, that red flag should go up and say, cousin, well, after we watch Al's probate Macarena, that isn't even in the Macarena. That's not even in the line. That's not even in the inheritance line. So you have to ask questions based upon what you know and enough that you know to know who you're talking to. Number two, have you pulled title? So important that you know what's going on that property up front. If you check the property appraiser and you don't see deeds, red flags should go up because you need to see deeds. Or better yet, if you don't want to spend the money on title, go to your favorite title company and say, hey, need you to pull the deeds here. We need to see what's going on. If that saves you money, wonderful. But pulling title is the best. Why? Because as soon as you pull title, you know exactly what the underwriter wants to close the deal. So also ask if there's a will. Do you have a will? Where's the original will? We'll talk about that a little bit more. But is there a will? Where's the spouse? Huge. Spouses in Florida have rights. You cannot exclude a spouse even from a will. They can still claim 30% of the estate, probate asset and non-probate asset, meaning even if there was a beneficiary designation that wasn't the spouse. Crazy. But spouses have rights. So had a deal come up recently where there was a husband and wife divorced, but then he moved on from her. And all we had thought were that there were just kids. But a big question I had was like, did that person remarry? And surprisingly, the answer was yes. So always default to spouse first, especially in land, because land in Florida is non-homestead. So we're not really always worried about all the other pieces. You'll see what I'm talking about, but always ask spouse and children. Two of the biggest things you can ask, because you may have a scenario in Florida where there's a spouse, but that person had prior relationship children, and let's say there's 2 of them, and they're not of that person that's still living, now you have 50-50 right there, so you need everybody on contract. We'll get into that.
Hey, Al,
Also,
just real quick on
yeah.
this. Just, I mean, because some people posting questions. I mean, just so everybody's clear, the attorney is going to handle most of the work after. This is just a little bit of digging at the beginning to hand it over if there's an issue, right? That's what you're speaking of here is, hey, you're so-and-so. So we're looking at a deed online and it's in this person's name and you're not that person. Who is this person? So you're just kind of putting little pieces together so that you can then take that and know where it's going.
It's so helpful to know a lot of these things up front, because here's what's happening. And this is why I'm doing it more and more. What's happening is I'll get a call and they'll say, hey, Al, we need a probate. How much? I have no idea what's going on. I don't know if it's 1 probate. Is it 3 probates? Like, for example, I had one the other day. It was a land deal in the Panhandle. And what we thought was going to be 1 probate, somebody dies, they had no spouse, no children, no will, and it goes back up to the parents. Well, everybody thought it was only going to be 1 probate until I evaluated it and we found out there was going to be a second one. So all of this is the basics for you to understand of what to look for. Again, there's never going to be a cookie cutter scenario. You're never just going to open the door, bust it open, go, do you have a will? Do you have a spouse? Do you have a children? It's never going to be like that. These are basic questions to help know, is this deal possible? And before immediately coming over and saying, we got a deal, how much? I don't know what's going on. So that's the basic idea. I love knowing what's happening. Also, is there a mortgage foreclosure? Are we expecting a tax deed? Crazy stuff. So for all of you that are in Florida or focus on Florida, keep going. Keep going, because we're hitting a huge point in about 15 years where 1/3 of the inventory is going to be a probate alone, because so many people own real estate that are baby boomers in Florida. So you have Tampa #1 in the St. Pete, Clearwater area. Obviously, Arizona is also a great place, I've heard, for probate, but even Miami, Orlando, and Ohio too. So you have a lot of potential in Florida if you are focusing on this probate niche. It's a huge amount. 1/3 of the inventory is going to have something related to probate. And don't forget about how many people have moved here since the pandemic, and also how many people do their own work. So, Office Depot, if you ever walk in Office Depot, you should go see it. They have their own section on legal documents. And some people think they can do their own legal documents. And you know what? Sometimes they make more money off the people that are doing their own legal documents because they're doing it all wacky and wrong. So a lot of people try handling this themselves, and when they do it that way, they're running into problems and they're eventually not going to convey correctly. It's going to be a mess. So you'd be so surprised how many of these things you're going to see really, really, really soon. Probate timing. I have to talk about this. Why, Jonathan? Because I did a boot camp a 1.5 years ago, and it was for 5 hours, not doing that ever again. And we need to make it like 1 hour and make it, snappy short. And I remember somebody after called me the next day and said, how was it? I was like, what do you mean, how was it? I saw you there. He said, well, I left. It was like 5 hours. I couldn't stay that long. I said, okay. I said, did you see the best part? He goes, what was the best part? I said, how fast I do probate. He goes, what do you mean? No, I didn't see it. I said, oh, I had it at the end. He goes, come on, you got to put it at the beginning while everybody's like paying attention and everything. So you know what? I learned from that, and now I put it in the beginning of the presentation because it blows everybody's mind, because everybody hears probate takes months, 6 to 9 months, a year, 2 years. Drop a comment for Jonathan so he can see it on his end. How many of you have ever heard probate takes 6 months, 9 months, 12 months, a year, 2 years? I bet so many of you are going to be dropping comments in there saying, yep, yes, yep, 12 months. I mean, so many. And this is the massive misconception, especially when it comes to Florida. There are many probates I have done in a matter of weeks, a month, 2 months. And I'll talk about my fastest one, which has got the biggest disclaimer of all of it, because it's a small county in the middle of nowhere, but it was really fast. Timing is the biggest misconception when it comes to probate. and I'll dive in. There's ones I've done in Hillsborough County in a week. So when I say a week, I mean all of the information we have all gathered. Then I take all the information, we file it in court, and then that's the timeline that starts the week. And then we get the court orders, and the orders, it's done. So people ask, wait, a week, it's over. Yes, it's over. And we take those orders, and those orders go to the title company. So I've done ones in Hillsborough in 1 week. I've done some crazy wackadoodle ones in Duval County, and I'll zoom through them later, but this is another one. I did this one with a major investment firm here in Jacksonville, Yellowbird. They had a crazy deal, and this could apply to land because it was non-homestead. I think this is a great story for land. A guy dies. There was a surviving spouse. Well, she also died after. That means a second probate, just FYI, second probate. And the question was, did they have children together? So then it would go immediately all to her, or did he have different children? Well, of the children that there were, he had one that was different. So that created a weird scenario of 50-50. Well, here was the problem. Nobody could find her. Nobody knows where the heir was. And I call it it was the Cuban probate crisis, the Cuban probate dilemma. It was one heir that nobody could find, and it was going to stall the whole deal. And there was no time. It was a looming tax deed sale in about a week. And so because of the non-homestead of the property, we were able to have everybody majority-wise on board, even though we were missing one heir. And that's critical because in homestead with Florida, you need everybody or you have a weird situation. So the fact that it was non-homestead, again, applies to land, and a looming tax deed sale, our radar was on and the creativity went through the roof. And we filed it, we filed it on a Friday afternoon. We got a case number that next Monday, and I'm talking like 4 heirs, full blown, what they call formal administration for the ones that know what that is, full blown, file it on a Friday, get a case number on a Monday, get a hearing on a Tuesday, and get the court order that same day. So we were talking like a 2-day turnaround time in Duval. There's a hustle that we have in what we do that we can make it happen, and I just get it done. So we've had crazy deals like that. Broward County, anybody familiar with Broward? Probate doesn't have to take forever. Probate can be a matter of 30 days. And you're talking, that's a complicated county. And that was right before COVID hit. That was actually right around when COVID hit. I think that was like February 15th to March 15th, 30 days. I've had crazy stories. So when a lot of investors will come to me and they now know to get the stories, which many of you now will too, get the stories ahead of time. It helps to know what's going on. So instead of the, we got one, we have no idea what's happening. I've had investors that'll say, hey, Al, I got one, mom died and there were 7 kids ever, not how many are surviving, ever. Why is that important? Because for contracts, you need everybody. So of the 7, 2 died before mom. And when that happens in Florida, when they predecease, that interest of one of them drops straight down to their lineal descendants, and they had 2. And then the other one had 3. I'm not expecting you to know this. There's no way. But it helps working through with who is there, where is everybody? So in this case, we had like the 5 grandchildren, and of the other 5, this is big because you may not run into probate, but this will help you. One was incompetent, and then the other one was in prison. What are you thinking immediately when you think incompetent and in prison? Drop the comment below. I know you all are thinking it. Power of attorney. Where is the original power of attorney? And big one, not just that it's a power of attorney and that says POA. Does it allow for a real estate transaction? And does it comply with title insurance for closing requirements? That is big. I didn't know that until a couple months ago. I thought it was just enough that it said real estate transaction. It's also got to be in compliance with what a title underwriter wants for closing and closing document signage if that person can't sign. And in Florida, they need the original POA. Make sure you get it to the title underwriter right away so they can examine it. So those are some facts. Yeah.
But before you keep going, just to answer something here, most people commented, move on, deal's dead. So they're not even thinking power of attorney. So this is where this is helpful, right? To be able to understand that these deals aren't dead. It's just knowing how to handle them. And again, knowing just what information to get so that you can get it to someone like you. And another comment that was made that I think is really important here, that's great, is somebody said most attorneys are not willing to do this. And that's one of the reasons that we've highlighted the fact of work with the correct professionals, because there's people out there, real estate attorneys, you're a real estate attorney, but they're kind of like everything, right? We do some probate, we write mortgages, we do this, they're kind of like an all-in-one. And can they do probate? Absolutely. But those are the ones that everybody was talking about that I've heard several years, I've heard months, I've heard this, because they're focusing on everything different. So can they do a probate? Absolutely. And we had one of our students in the last group that was dealing with one like that. Was it moving along and were they doing it well? Yeah, but it was taking 6 months, right? Whereas another student worked with you, and I'm not going to mention their name, but they started in just in May, and I believe it was 7 heirs and it's done, right? And here we are in July with 7 heirs and done. So it's focusing on the right relationships and the right people to work with, and that's where like you come in there. So just clarifying a couple of those points are helping it, because I'm seeing it here. Unfortunately you can't see the comments, but I'm seeing it, and it's like maybe speaking to that a little bit as you're going along.
No, this is great feedback, and Jonathan, keep chiming in whenever you want, because it's really interesting when the initial comment is dead deal, right? So I'll tell you a dead deal that's probably not going to happen. Now this is dead deal. I'm going to make a new PowerPoint slide even after this presentation on my new ones, and it's going to be called point of entry. We're not going to jump into partitions today, but a point of entry. So I had a deal come across my desk. It was titled 3 ways. One was a trust, the other was a deceased person, and then the other one was a deceased person. Here's where there is no point of entry, and you probably should move on. First of all, with the trust, we tried to see where's the trust, because in Florida, all you need is a copy of a trust. So if we at least have a copy of a trust, there may be a way to get what they call a trustee appointed, so there could be some kind of transaction for at least a third. Well, I don't think anybody found the trust, so there's no point of entry on that 1/3. Of the other deceased person, I said, what's the story there? And they said, oh, they died in like 1998. I was like, okay. I said, how many children ever? No spouse. How many children ever? 5. Where are they? All dead. Okay. So we don't even know what's going to happen there. It's going to be like 6 probates there. So, okay. What about the third person? No real point of entry then. You can imagine on a land deal, forget it. 6 probates out. And then the last third, I said, what about that person? They said that was that person's brother. And there was like another 3 probates for that. That is where you truly have to analyze each one. Sure, there are going to be ones that don't make sense. But for something like this, like a power of attorney, I didn't start anything until they took that power of attorney and brought it to the underwriter. If that underwriter would not have approved that power of attorney, I would have said the same thing. I said, there's just no way. You're going to need guardianship. And number 1, I'm out on that one. Number 2, that's going to be way long, way expensive, absolutely crazy. So I'm glad that was brought up. And yeah, Jonathan brought up another great point. I was at a presentation in April, and I did a probate presentation. And after it, the host said something interesting, like Jonathan said. A lot of lawyers do a lot of different things. Yeah, we dabble in probate. Yeah, we dabble in this. I focus on this niche. I focus on this. I'm working on some wackadoodle ones right now. I got one that I'm doing in South Florida, 5 probates. People died in the 70s and 80s. I have another one right now where Brother dies, it goes to mom. Mom dies, it was non-homestead. They're missing one heir, so it's that yellow bird deal I just showed you. I mean, crazy stuff. So don't the one thing I would say, don't shy away from it. Keep trying it. Keep going. Again, I'll just keep running through the times. I did that one in 8 days, Jonathan. There's times I've seen double probates. Huge to pull title up front. We did this one 3 days each in Duval during the pandemic. It was crazy. So these probates can be a matter of days. Lee County, anybody knows where Lee County is in the Fort Myers area? 20 days, all during COVID-19. It was crazy. Nassau County up here in North Florida, done that in 4 days. Putnam was 3 weeks. Everybody knows where that is, hopefully. Clay County, right by Jacksonville, did that in a day. That was my record time before this story. So 2020 brought a lot of great stories, a lot of great action. And I got to meet with an investor in like June of 2020. We did Zoom. We sat down. He said, I heard about you. I said, great. He said, when I find one, I'll let you know. Fantastic. Didn't hear from him for about 7 months. And I'm waiting around. I'm doing my thing. It's funny how this all happens. I wait around for 7 months, and all of a sudden I get an email from the investor. He said, hey, I got one. I said, all right. He said, it's really been with this lawyer who hasn't been retained and hasn't signed anything. It's been with the lawyer for 7 months. I said, okay, what's the problem? What's the catch here? If it's with a lawyer, something's wrong. The lawyer hasn't started it. He keeps quoting on the deeds and the recording and the doc stamps. I said, okay. He said, something's not right. I looked at the file. Mom dies 2004. There's only 2 heirs. That's it. There's no more than that. Just 2 heirs, both alive, both on board. So I was like, what am I missing here? He said, nothing. There's nothing else. I even asked the heirs. I said, am I missing something? He said, nothing else. And that was the point I realized the laziness of some of these files being held with some lawyers. And we were able to get the probate. They retained me. We had both on board. So this is the crazy story, right? You're talking about people that died years ago. It was a small county. Clearly, I don't know if there was anything to do that day, but I got everybody to sign, both on board, filed it on a Thursday at 2 p.m., got court orders that same day at 4:30. Hernando. Big time. 2 hours. Obviously, not every probate's going to be 2 hours. There's just no way. If I ever beat that time, I will let everybody know. I'll probably post it on Facebook as crazy. But I'm not trying to break record times. I'm just trying to show you that these things can be done. Also, figured out a way that we can avoid quiet title if the probate's done. Just make a note of that if you're able to find out how to get the probate done and you've bought a tax deed in Florida, we've got a way to bypass the whole quiet title. So what's unique?
Since you brought it up, because it's come up a couple times here, can you explain real quick the difference between probate and quiet title? Because people are asking. Or when you use one in place of the other, basically, I guess would be maybe a better way of wording that question.
You can't get around probate in Florida. So if somebody dies, they own real estate, you're not getting around it. You can't just use quiet title. So probate is the function of transferring, so it's going to heirs. Quiet title is a lawsuit to silence clouds on title or interest on title. So there may be liens, there may be, you may have bought a tax deed and it was owned by an estate, or you thought you had true record title and somebody never deeded out. So the quiet title is this lawsuit to satisfy title insurance. So they insure the policy for a buyer, but it's to silence interest in the past that are inferior to that person that owns title. It is not an Al Nicoletti 2 to 4 day special on the timings. Quiet titles are expensive and they can be lengthy, but they are rather cute strategies if you have the time and the wherewithal to do it. For example, we have one right now we're going to do in the Panhandle where it was a probate, title transferred as a life estate to a spouse and a remainder to 5 kids. Well, if anybody knows about life tenants and life estates in Florida, A life tenant has a duty to pay property taxes. Well, this life tenant was not. So I have all 5 that retain me, and we're trying to silence their interest to say, you failed to pay property taxes, wipe them out. Those are ways to use quiet title. Or a wild deed. Anybody's ever heard of a wild deed? A wild deed is a deed totally unconnected from the chain of title. They call it an interloping deed. So, for example, A to B, B to C, C to D, and then you have T to Z, something completely out of the chain. We use a lawsuit, quiet title, to silence that so C could sell the property. Things like that. It's a lawsuit to silence interests.
Yeah, just for example, guys, I mean, since we're talking from land perspective and things, just a real quick on ones we've done, because this does come up. And just so you know, these come up and there's good money to be made in them. We had one in Florida that was 3 heirs, never done right. They were trying to sell it, but probate was never done. And so in that case, it made sense just, hey, let's just do probate because probate worked. Now we had one that was in another state that was 3 heirs, but one of the heirs had since died. And then there was all question as to where his interest there lied. And the attorney said, because there was no clear defined path, they couldn't find anything, probate really was an issue. If they could find it, probate still would have been an issue, but they couldn't find it. So we had to do the suit to quiet title there, which still worked out. We got the interest from the other 2 parties in advance. So we now retained the majority ownership of the property. And then we got their cooperation to basically follow through with the suit to be able to basically sue them so that we could get the other interest, that other 25% of the property. And that turned into a good deal as well. But just to the point there, what you were talking about the timing, because that's come up here a few times too. I mean, one is just filing documents because it's a dead person, right? The other one is literally a lawsuit. So you've got to publish things. It's got to be open and notorious. It's got to be like in a newspaper, on a website or something, and it's got to be out there a certain amount of time, and you've got to serve people and all. So that's where, for everybody asking, that's where the time, if you want to speak about that, you're much more, you could speak on it much more eloquently and detailed than I can, but it's more of all the process involved and the rules and the regulations as to how long things need to be there, as to why that can't be sped up at all.
You have to do a diligent search to find these people that are in the back of the title. They may be dead, and you have to even search for their heirs. Quiet title's a whole different ball game, a whole different thing that I now require that if I'm going to be taking on a quiet title, it needs to either be a Zoom call or it needs to be at least an hour-long conversation, because people have to understand there's a lot more to it than just, hey, mom died, 3 heirs, one of them is calling you. How fast, how long, that's it. Quiet title is different. So just know when you're thinking of these timings, you're like, wow, what are the most 2 important things when it comes to doing deals? You want to know how fast can these be done, and money, time and money, right? Well, the best part about what I do, I wait until the end to get paid. So a probate lawyer doesn't charge upfront attorney's fees. I can wait until the end. The heirs don't even have to pay it. You can pay it for them as long as they consent. I put this here so you know. So you're not like wondering, well, why didn't he tell us about this? Because you now know that timing it can be huge if it's fast, and somebody that can wait to get paid at a closing is big time. Because when I do it, I wait until the end. Boom, it helps everybody. I don't stall anybody's deal. So more knowledge about this, so you know. When is probate needed? And when is probate not needed? This is good information for you. Everybody has heard of the tenancy by the entirety, husband and wife. If both of them are on the title and the husband dies, record the death certificate, it goes to wife. No probate. If you have brother and sister and the probate, there's no probate here, but if it says brother and sister with rights of survivorship and brother dies, it all goes to sister, no probate there, right? But if it's brother and sister in no magic language and brother dies, probate for brother. It's about magic language on deeds. You can help yourself a lot by reading the deeds. If you look at the property appraiser or you look at something on title, it helps to see it. Like, there's investors out there, I'm very impressed when they look at the deeds and they'll say, it was 1, 2, and 3. and it had joint tenants with the rights of survivorship, and 2 died. We only need to do 1 probate. Great, fantastic. If it's 1 or 3, it doesn't matter to me, but at least we know what we're working with here. So also ladybird deeds. Anybody's heard of a ladybird deed? I think they're in North Carolina, but in Florida, life estate deeds and enhanced life estate deeds, they call it the ladybird deed. So what it is it's a retitling of the property, that person owning it for their life, and they choose beneficiaries. So upon that person's death, the heirs record a death certificate and title shifts immediately to them. No probate is needed. And that person with a ladybird deed can revoke that life estate deed, the enhanced life estate deed, before their death, and they can change it again to somebody else if they want. Obviously, there's got to be restrictions with homestead property, but we won't cover that today. But what you need to be mindful of is only husband, only wife, or the one I saw recently, ex-husband, ex-wife, and they never retitled the deed. And it just stayed that way. There was never any other deeds after that. If you ever see that and there's no magic language, or it's only husband or only wife, doesn't matter how long they've been married, and that one that's on the title dies, you need a probate. Because the next question becomes, did they have children not with that wife or husband that died? Because then you have a 50-50 situation. So Florida gets a little weird with this. So just know when you need it, when you don't need it, you're looking for magic language. And when you need it, there's no magic language. So big question that comes up. I can do a video on this every week. I can post the same video. If you go on my Facebook page, you'll see I have a video on this probably 2 or 3 times. Wills do not avoid probate. Florida, they do not avoid probate. So if you ever go to a seller and they say, yeah, we have the will, I'm the executor. Okay, that's wonderful and everything, but that will you still need to go through probate. So don't be fooled when they say, oh, I have a will, now we don't need to do any probate. You still have to go through probate. So
and from the real estate investing side, all the time, we're going to get that. Just so you guys are aware. He's talking about that. It's not, you as you get growing in this business, whether it's land or anything, I mean, you're watching this from land perspective, but whether you're watching from anything, people all the time are going to say, I have a will, or it's in my name. No, it's not their name. They're paying the tax bill. The deed was never put in their name. Their tax bill's in their name, that type of thing. So we hear that. I mean, we're doing massive deals, but we hear it every single month at least. And they're wrong all those times. So just to put it in a little real world perspective, from our perspective, not the legal side, from the investor side, all the time we hear those two things. Like, I'm paying the tax bill. Good for you. It's basically, good for you. You're paying the tax bill. It's in your name, but it's not, you don't own the property. You're just paying the bill. And then the will thing comes up all the time too. I have a will. And it's like, well, that's nice, but you didn't do anything with it yet. It's like, you just have a document. You don't have anything else. So from the investor standpoint, you're going to hear that very often.
And they sound very convincing too when they say it. They hold it up, they fan it, they wave it, they show it to you, they put it right in front of your face. Just because they do all of those theatrics doesn't mean that probate's avoided. And when they say they're the executor, another red flag should go off, and remember this and say, Al said something about you need to take that will, and that will needs to be examined and looked at, because you may not even need to be an executor for this kind of probate. Maybe a simple probate. So don't let them try to do that either, where they're like, I'm the executor and everything. Just know that it guides the probate process. Wills guide it. And if there's a will, ask, where's the will? Who is it going to? Read it, right? So when you're looking at a will, it helps. Again, I'm not saying that you're doing all of this and I'm doing nothing, right? It helps. So it's a puzzle to work toward, to figure out, do we know what at least is going on? Is this doable? Do you want to waste your time or not waste your time? That's really what it comes down to. So who gets it? So when you're looking at the will, you're not looking at the part of who is the executor, or in Florida, it's who's the personal representative. What you're really looking for is who's getting the real estate, right? So there's things called the triple R clause, the rest, residue, and remainder clause. Who's in that? Who's named there? That helps me know. And I had a lady the other day, I said, can you tell me like what it says? She goes, hold on, let me read you the will. The last will and testament of John Smith, dated. I was like, I didn't need to hear the whole will. I just need to know the triple R clause. That helps me the most. So know that. And also the original will. We need the original. Don't even get me started about copies. Copies of wills are presumed to not be a will, and therefore they need to be proven that it wasn't revoked or destroyed. It's crazy in Florida. So very, very, very tough to get over. Not impossible, just expensive. So what happens when there's no will? So many times. I mean, drop a comment. How many of you have come across a probate deal where there is no will? So, shocking, everybody hears about the will, but then you hear there's no will. And you get investors that know this more and more. They know intestate, they know testate. Testate means will, intestate's no will. Okay. So they die without a will. How many of you are running away? I hope none of you are saying yes. Don't run away. Just because there's no will, there's a way to do this whole thing. So I can't do it on the screen, Jonathan, but when I was studying for the bar, I had to remember what the inheritance line was, because a third of the section of multiple choice was wills and trusts. So we had to remember what intestate was. So somehow this has turned into the probate Macarena now when I do presentations, but you have to remember, who are you looking for you when you come across these deals? So you always start at the spouse, no spouse, children, grandchildren, great-grandchildren, and then none of those go up to parents, grandparents, great-grandparents. None of those. You go out to brothers and sisters, half-brothers, half-sisters. None of those. Nieces and nephews, and aunts and uncles, and eventually even down the paternal line as well. Why am I telling this to you? That's who you're looking for with no will. So you find out that mom dies, dad dies. You ask, is there a will? They say no will. What's that thing Al talked about? Spouse. Is there a spouse, surviving spouse? Are there any children, grandchildren, great-grandchildren? Are there any parents, grandparents, great-grandparents? Brothers, sisters, half-brothers, half-sisters? It's crazy. It keeps going on and on. Eventually goes to the state of Florida, but you have to ask these questions. Boom. Right here. What's the big picture? These are the people you're looking for. These are the people that would have to go on your contract in order, and or 1 and 2 if they're prior relationship children. But these are the people that you're looking for. I have one right now, number 3. It's going to the mom, but she's dead. She died after the brother. This is that one where now we're missing another heir. So 3 people on title, 1 is alive, 2 are dead. The brother, no will, no spouse, no children. Parent, yes. Mom was living when he died. So we're moving now his interest to her, and her interest out to their siblings. It's crazy. So this is who you're looking for. Eventually, state of Florida. We haven't had that experience, but 2020, when you ask questions, don't let them get away with this either. And this is important. When they say, I'm the only surviving one, don't be fooled. That should be a red flag. I'm the only surviving one. Something's not right. The question is, how many children ever? How many heirs ever? Because if all of a sudden they go, 10. Oh, okay, like that changes everything. Now, if they say 1 ever, that could be really good, because that's probably it. But ever, because I had a story where sister dies, no will, no surviving spouse, no children ever, no children, no grandchildren, no parents, no grandparents. But she had 3 brothers and sisters. And at the time, it was 3 brothers and sisters ever. So we had an issue with the homestead property, not important, got it resolved. 2 days before the judge was supposed to sign those orders, I got a phone call from one of the brothers, not the client. And they said, Mr. Nicoletti, we have a question for you. And I said, okay, what's the question? He said, well, we know you have us. What about the other 3 brothers and sisters that died before sister? And I'm like, Nobody ever told me about that. I mean, we were for sure that this was it ever. Come to find out, one of them had one child, the other had another child, and then the last one had 5 children. So we're not talking about land for this story. This was homestead property. All of them had to sign the contract. All of them had to sign the closing documents and the deeds and everything. So from this story, got done. Closing took 2.5 months. Probate, I made sure it only took a month because I sat in on a Saturday and got it all done. But 10 heirs, homestead. But that last line is incredibly important for you. It's not about surviving. I had a title company have a situation, and it was supposed to be really simple until they said, it's only me that survived. And then I said, let me ask that again. How many ever? And they said 4. 4 others that were already dead, and they had children. Nobody knows where they were. Huge problem.
So just a quick question on this. I mean, you're speaking of Florida. You're an attorney in Florida. I've worked in about 5 states myself. I've kind of seen the same flow, basically. I mean, is this basically, I know you can't speak for everything everywhere, but is this kind of just in general 30,000 foot view what you want to be looking for regardless of where you're working, because this is kind of the way it just normally flows?
I think it is. I mean, of course, you can have different rules and stuff in Texas and North Carolina, but I think these are basics to know who are the heirs. Like, who are they? Even if you don't even have to use them, at least you ask enough questions to know and say, hey, I've dealt with Florida and we have to know how many are ever. And then who knows, not saying this is how it is, but then you go to Idaho and it's like, we only need to know how many are like surviving. That's it. You don't know that. And it's important to ask as many things as you can. And again, you're not going to get everything. It's okay. I mean, as long as you get enough of the big story to know, that helps a lot.
Well, that's also the point, right, where you would make a phone call to somebody like yourself in a different state. I know, like, for example, in our group just a couple weeks ago, somebody was dealing with something like this in Arizona. You don't work in Arizona, but you actually gave them a name. You're like, hey, I know so-and-so in Arizona. They're the go-to person there. So then they could call them and say, hey, what do I have to get? What do you need? Right? It's like, because every state's a little different. So you're saying here it's ever, they may say, nope, we only need X. But at least you know at that point, you're still working with the right people and the deal's still moving forward. You have the probate attorney that's working with you. You know what information you need, and then you're able to kind of move it forward as opposed to just getting stuck and sitting there and being like, oh, well, he's only talking about 1 state out of 50. It's like, yeah, that's true, but the principles apply. I mean, there may be little things that change here and there, but it still exists probate exists in all 50 states. This isn't something that's like random just to Florida.
Yeah, I mean, look, if you're in a different state other than Florida, finding somebody that knows it in and out, that is, and again, the key is what Jonathan said a little bit in the beginning, which was some of these lawyers will say, oh yeah, I do probate, dabble in this, dabble in that. You're not looking for that. You want somebody that's going to be like, no, this is what I do. I do this. And that is what you're looking for. It's hard to find, but I mean, if you can find it, that's great. Of course, I put this here not for everybody to know and memorize and like, what do we do? What's this creditors thing? People ask about this, and you don't have to get overly analytical with creditors. But if somebody is been dead for less than 2 years in Florida, we have to know, are there any, is there anybody mailing the house? Are there any known creditors? Do you know if mom or dad had a Visa bill, a credit card bill, a Home Depot bill? We have to know those things. And that helps because you're already at the house. So why am I telling this to you? Because when you go for your appointment and you go to meet these people, you're already at the house. So you could be like, well, wait a second. If you know when they die, date of death is less than 2 years. You can say, are you getting any mail? Like, do you know of any issues? Helps big time. Many times they'll say, nope, mom had no debts. Other times I've had ones where there are 18 creditors. 18. Homestead property can't be touched. Land's different. Land is an attachable asset in Florida. So we really got to know where they are. And I ask for critical documents to help lay a foundation so those creditors can't make claims. So big time with creditors. Now, if it's been more than 2 years from date of death, probate goes faster. I know North Carolina is a little different, right? I think North Carolina, I've heard if it's more than 2 years, you don't need probate. But in Florida, you still need probate, even if it's been 10 years, 20 years, 30 years. There's a hard bar for creditors in Florida. 2 years after date of death, we don't have to do that newspaper thing. We don't have to do notice to creditors, nothing. Probate goes faster and we don't have to deal with that stuff. Mortgages still stick, major improvements and security interest still stick, and Uncle Sam is not going away. So let's not be too cute about those. Those still stick with the property no matter what. Homestead, this is land. So just a basic understanding. It's about where that person lived and resided. You're not going to see homestead with Florida in land. So we won't go over this too much, but if you ever see it with a primary residence, you need all heirs on contract. And it doesn't mean, did they apply for the homestead exemption? Did they live there? Did they reside there? But this is land. So with probate, people will ask, who do we reach out to? Do we reach out to the personal representative, or there doesn't always have to be a personal representative. There just may be heirs. That's it. And a little nugget for everybody. This is actually a great nugget while I'm thinking about it on the top of my head. If you're ever looking for a lead and you can't find somebody, a death certificate always has an informant named on it. In Florida, anybody over 18 can get a death certificate without cause of death as long as you have the person's name and the exact date of death. Not, it was sometime in 2019, like exact to the date of death. That's a little nugget for you that are all paying attention. I'm sure there's some eyeballs that are opening up and some eyebrows raising like, wow, we didn't know that. Huge stuff that you can learn from this, but you don't always need a personal representative. Usually it's just a petitioner. And sometimes with the land deal that we had just like a month ago, Jonathan was talking about with 7 heirs, we just had all 7 go on title. It made it so much easier because once you start having a personal representative, it gets really expensive. Title commitments, they are your best friend. I can't stress this enough. Boy, did I learn the hard way recently. And, you got to get back to basics with this. So crazy story, land deal. Guy owns a property with another partner, foreign, out of country. I think it was one of the Asian countries. He dies and probate was never done for his half. So on title, we didn't see title, but we saw the death certificate. It was one name. There was no AKA, also known as. So always grab a title commitment. And this is the story that just keeps sticking in my mind is we got the death certificate. We did the probate. Probate was done. We finished it. We got it done in like 3.5 weeks. All of a sudden, boom, title commitment comes back. Should have waited. On the title work, it had a different AKA name. According to the translator, it's the same name in the language, but it was a different name reflecting on title. If we would have known about that at the time of the probate with the title commitment, we could have resolved it in the same probate proceedings. Now it's been a crazy like email fest back and forth on email chains about trying to solve the same name, one in the same affidavit. So that's a little story that I went through that I'll never forget. That I'm like, I'm not doing probate without seeing a title commitment. I'm just not doing it. Just so you know, their bottom line forensic examinations, always get one. They tell full stories. How many mortgages? What's the back taxes? How many nuisance liens, demolition liens? How many defects are in the title? How many people didn't deed out correctly? How many people we now need quitclaim deeds from? How many probates there are? Who are they? Sometimes the title doesn't even know they're dead. So always knowing how many probates are needed, that's critical. So talked a little bit about this. This was a crazy story that I had. 2 people bought property before they were married. You would never believe this, but 2 people bought property before they were married as single and single. A year later, they got married, never retitled the deed after that. Then one of them died. Then, like 10 years later, the other died. And the heirs of the one that died last were like, we need to do a probate. That's it. We just got to do one. That's it. Well, title, I thought it was one at first because they were married. You would think, oh, they were married. Doesn't matter. But here's what happened. Title comes back and says, one died and had different heirs, and this one died and had different heirs. They did not have the same children together. So title insurance wanted two probates, one on one and one on the other. One had a will, one did not have a will, and then the other one remarried too. So asking these questions, who remarried, what happened, what's the story, so critical. So many crazy wackadoodle stories all the time. And anybody's ever heard different probates, summary, formal, ancillary, doesn't matter. Doesn't for you, you just seen the words, you've heard the words. I think on the one that was referred, they even knew what a summary was. Sometimes, many times it's summary, sometimes you need formal.
Can
but
you,
the one, yeah.
Sorry, can you actually spend a second just on summary? Because we're talking about land, and most of my deals in Florida have fallen into summary administration. I know the one that you're speaking of, we had thrown it out that it was probably that based on the value and stuff. So since a lot of our people here are working in vacant land, that does fall into that category. And in Florida, it does come into that category a lot. So could you just maybe spend just like a minute just explaining what that is? Because that doesn't exist in other states, just so they understand what that is.
Summary means a faster procedure because the amount of the assets is under 75,000 or date of death is more than 2 years. That means we can get just enough on a petition to get the order that will satisfy title insurance. It's a faster way to get probate through. I love it. I think it's the best because I'm that style, file it, get it done, out, done. That's it. That's summary. But what you're finding, and Jonathan, you've probably seen it, are the ancillary summaries. I made sure to even talk about that too. Ancillaries. Somebody died and resided in another state. They resided in Idaho. They resided in Washington. They resided in Texas. But they owned a land here in Florida. This is common. This is what happened that I picked up in the middle near Okeechobee. I've picked it up in Fort Myers. I've picked it up in Charlotte County. They own land, and it's never gone through probate. They think, oh, we did the probate in California. We don't need to do the probate in Florida. You do. But it's an ancillary, means secondary, but it can qualify as faster and quicker because if the lands are like 10,000, 20,000, even if it was land that was 60,000, it qualifies for what they call a faster summary. And many of these people didn't even know they had land. So you're not going to find land. You will, but you're rarely going to find land where this land has been sitting for less than 2 years from date of death. These are lands that could be sitting for 10 years. So we can use a summary administration to get these things to go even faster. It's an amazing, we have a way, Jonathan, people will love this. I figured out a way that we don't have to open up a probate out of state in order to open up the Florida probate here. So if probate's never been done or it's already done out of state, I have a way to get the probate done without involving anything out of state. That is huge. A lot of people don't know that. They think that, oh, we need to open up a whole brand new probate out of state to open up the probate in state. It's not how you do it. So any questions on that before I just kind of go into a little bit of the trust thing? Because some people run into this.
I'll see if any pop up. But I mean, just so you guys know, I mean, just again, speaking from the real estate investor side as somebody that's worked in Florida, that ancillary probate is one that we've used quite a few times because a perfect example, the one I talked about earlier with the three heirs, the guy died in New York, owned this property in Florida. Property was worth about $30,000. And so everything was done up there. Children just assumed, hey, we've got it here. Well, they didn't. It wasn't done right, but it was something where we could take that and now use that in Florida and be able to save time and money and effort because of that, instead of doing this whole process again with the Florida court. Because basically, and you could explain it, I mean, because obviously you're from the legal perspective, but my understanding that was explained to me, and maybe there's a clearer way, or maybe this isn't 100% accurate, but basically it's just petitioning the Florida court to accept what's already been accepted in another state. Is that accurate?
Depends, because what happens when, so there is some truth to that, to the extent that a probate's been done out of state. Many of these lands and property in Florida may be land that they bought, but out of state, they never had a probate done, or it was already done. And we don't even need to go to those issues. We don't even need to have what was accepted as done. Now, I have one that goes to what you're saying with South Carolina. We had one in South Carolina that was open, and the guy was appointed the executor there, and the Florida court had to recognize that he was appointed there so we could get him appointed here. But many of these little lands, we don't even need to go through all of that. The loophole is that it was never done, or it was already done, and we don't even have to involve anything outside of Florida. So yeah, it's a procedural thing in court. That's it. We make it simple, boom, done, get it done, out. The next thing. So ancillary is great. They told us in law school, Jonathan, that you would rarely see ancillary, when it wouldn't come up that much. I don't know. It's come up like at least 15 times for me this year. So I don't know if that's what they meant, that you'll see it less than 15, but it's crazy.
Yeah, I mean, it's probably a $75,000 or under house is probably not that common. There's some, but I mean, it's probably not that. So I can see why they would say that. But when it comes to land, and it's amazing. I mean, we just think about it from the land investing perspective. I mean, how many people bought land in Florida because they're like, well, I'm going to use this at some point. I'm going to do something. And then it just disappears, you know? And so they forget about it. They die, whatever happens. And we've had so many where the family didn't even know that some heir bought the property, and all of a sudden they're getting mail. It's like, what in the world? So this is not, an uncommon thing, at least in that state, because of, and if we go back 30 years or more, they were running commercials on TV up north that were like, go buy land in Florida and like buy it for this and do this and do. So tons of people have it. So I think from our perspective, the land investor perspective, it comes up a lot. Maybe not in general probate with homes and, everything else, but from the land only perspective, people from other states have bought land in Florida. The value is not super high. It's under that $75,000 threshold. So personally, I've seen it from the investor standpoint come up, quite often.
Hey, if it comes up, it's not hard to tackle. I mean, there's a way to tackle it. So again, another thing that everybody would think, oh, we got to do some big thing. Doesn't always have to be a big thing. So you know where to go for the investor perspective, and now you know where to go for the lawyer perspective. I put this here as just a bonus content, Jonathan, because people may do their leads and stuff, and they may mail and they realize, it's not a probate, but the property's titled in a trust. And everybody's going to learn, Al said trusts avoid probate, so we don't have to go through probate. But where's the trust? Is there somebody that has authority to sign on behalf of the trust? And if there isn't, now you need what they call a trust administration. It's another court process. So if you ever come across property titled in a trust, like you see it's titled in a trust, John Smith Revocable Living Trust, may not need probate, but just be careful. Make sure you bring it through title to find out, because you think probate's avoided, right? We can close, but no, because poorly drafted trusts may not avoid another kind of court process that's like probate. It's in probate court. So if you see a trust, don't think you're out of the woods just yet. Ask, where's the trust? Where's a copy of the trust? If they don't want to give you the original, where's a copy? Why? Title insurance needs that. You can't get your deal done without them showing you where the trust is and who is the trustee. You need somebody to even sign as the seller. If there's nobody as trustee to sign, you now need what they call this trust thing. That's why Lawyers make words complicated. I don't think I'm making anything overly complicated. I hope not, but they call it trust administration. I like calling it trust thing because later when you come across it, you're going to think, what's that trust thing that Al talked about? Something simple to remember. If it helps you, it's great. Trust administration is another thing. And what is this all about again? Title insurance. Satisfying title. That's the big thing. That's what to look for. The deal has to make sense for everybody. I actually added a slide for you, Jonathan, so we can go through some questions. I'm actually going to do another land webinar in about a month or so, and some people were posting questions in advance of the webinar, and I was like, ooh, we can absolutely use some of this. They were asking, is there a way to parse the home leads from the land leads? I thought that was a good one. And many people will pull the property appraisers. Some lead lists will have a 0 next to the street, or they won't even have a house number. That is how you parse house leads from land leads. Thought that was a great question. Also, best approach.
Just really quick there, just to be clear, guys, he's talking about on a probate list. If you're getting a probate list, obviously, if you're getting a land list, it's going to include the probate deals anyway. So you're going to get them. So basically, from our training perspective, when it comes to land, we talk about getting a vacant land list, and these probate deals are going to show up on it. And the key here that I think hopefully you've learned in the last hour or so is we saw a bunch of them: deal dead, deal dead, deal dead, deal dead. It's not deal dead, it's deal there. This is jump in and take advantage of it when those come up.
Yeah, it's not always deal dead. Very I've learned that there's a way to make these deals work. So have hope, but have realistic expectations of money being expensive and what does the deal work for you, right? Because that's number 3 right there. But yeah, so we got home leads versus land leads. Also, somebody had asked best to approach the estate timeline wise after death. Timeline, again, we kind of talked about that. With land, you're looking at anywhere from a matter of weeks. The one that I did with the 7 heirs, that was land. I think that was like 3 to 4 weeks. And so you could be looking at a matter of weeks, a month, 2 months. You're not looking at 6 months. You're not looking at 9 months. These times are absolutely insane. And then they had made a comment, said that they did not complete an ancillary probate. The person lived out of state. There we go. So the person lived out of state, they resided out of state, but probate wasn't done here in Florida. What do you do? And Jonathan and I just talked about that. There's a way to get these done. And I've seen it personally to get them done without even involving the out-of-state probate. Also, something to be familiar with, because it's something I'll even tell you about: exemplified copies, certified copies. What in the world is exemplified? It's like doubly certified copies. So if we ever need a transcript of the proceedings in an out-of-state court in Florida, we need the exemplified copies, number 1. If we can't get them without it being at a huge expense to the client, we can use certified copies. The court wants to see if it was properly done out of state, or where's the will. Sometimes they'll have a will. We need to see that will. So just be aware of the words. If you're like, what is exemplified? It's like stamped like 3 times by the deputy clerk. It's crazy. Also, who signs the probate contract? Is there a probate contract? It's just another real estate contract, really. That's it. It's just, you can put that closing subject to probate court orders. And who signs it? Usually the best practice is all heirs. Everybody that you find, just get everybody on board. Because if there's small land deals, there's probably not going to be a personal representative. Jonathan, just like the one with 7 heirs, they all sign the contract, I think, and then they all sign deeds. They all are going to have to sign deeds. So those are some questions that came out. I thought those were huge questions.
That happens as you're going, right? I mean, just so people understand, like, because you're not going to know that at the very beginning. You send a contract in the mail to somebody, one person signs it, and they send it back. That's your starting point. And then as you learn that, hey, this really needs more, it needs to go through probate, that's when whoever is doing that is going to, if it's in Florida, you're doing it, whoever is going to make sure that all the people needed are signing it. So don't worry about that right from the get-go. I mean, because you may only know one, right? You may not even know it's an air thing. I mean, who knows? You send it to them, they think they have the right, they sign it, and then all of a sudden it's like, oh, we don't have complete rights. This other person does, this other person does, this other person does. And then that's when those start getting added in as you're going down that process. So it's not at the beginning trying to figure this out. Oh, I'm making an offer on this property. Let me look this up. Oh, there's 7. You're not going to know that. It's get the signature you need, get it rolling. And then you're speaking of after the process is going. Now we're focusing on getting everybody involved that needs to be.
Getting everybody involved. It's best practice to get everybody involved. You're going to need everybody because the title insurance underwriter is going to want everybody. So great practice. Look, I go anywhere in Florida, from Key West to Pensacola, Tampa, Orlando, anywhere in Florida. I do probate, all of those places. I even put some of my other niche practice areas up here. I do the probates, simple, complex, weird, wacky, different. Trust administration, trust thing. We'll never forget that. Quiet title. We kind of talked a little bit about that. Partitions, a whole other thing on forcing the sale, where one wants to sell, the other doesn't want to sell. Maybe you buy out one of the interests via a quick claim and push it to an auction, or maybe you buy it back. Those also as well. Specific performance, buyer backs out of the deal right before closing. You're a ready, willing, and able buyer. They were ready right up until the last minute, and then they back out and try to sell it to somebody else. Those are my niche practice areas. I don't do everything. I don't do closings. I don't do contract review. I don't want to. I love monetizing the business and what I can crush it in, and I know stuff very well in, and I love probate. I love it, love it, love it. Find me all over the channels: Facebook, Instagram, YouTube. Add me on there. Find the business page. I have a business page. Follow me on there. Find the Instagram and YouTube channel. Subscribe to it. Find the website, alnicoletti.com, and find the Alan Nicoletti Show on iTunes and Spotify. Great guests every Wednesday night at 8 p.m. You can find it on the YouTube channel or find it on my business page, and I share it on all the major investor pages. So, Jonathan, hey, this is great. I mean, this is fantastic stuff for people to know. And I loved it. I appreciate everything on this.
Yeah, it's been great having you. This was a great first show. Super excited about that. What you just showed there, we'll put out in a moment. We'll include it, so your contact information is there. If anybody has anything from Florida, feel free to reach out. As I mentioned, I mean, we've had a couple students that have gone through our training. I mean, Jamal just texted me. He's like, you can talk about me. So, I mean, Jamal's using you for one right now. The other person that did the 7 is using you getting things done. Obviously, it does have to be cost effective and it has to make sense. I mean, I understand that some people talk about, these land deals that we're picking up for in the middle of the state that are dinky lots, $500 purchase, and it's a $5,000 piece of property. If that's a probate issue, that's a move on. I mean, let's be realistic. It's not worth the expense. You're not going to, it's going to be too time consuming. But I think Andy here made a comment about, he's making about $18,000 on the deal, so it's worth it. Jamal talked about making about $25,000 on the deal, so it's worth it. So it's got to be cost, just like everything else in this business. I mean, it's got to be cost effective. But Jamal made a great point, and he said, that he to bring out was, he's passing this along to his seller because it's basically they're stuck with it. They can't do anything with it. So you can use it as a negotiation tool. You can get your price point down. There's a lot of different things that you can do as the investor with this to still help you. You can, we're going to split it because they're still stuck. They can't do anything with the property until it's done anyway. So it's like, hey, I'm here. I'm offering you money. I'll help you get through this. I've got the resources. You're obviously not giving them their name because you're not helping them yet, but you start passing it along. It's like, and then you've got this guy and you can be like, hey, he can get them done quick. And so that's huge. And one other point to what we were talking about with him is when he talks about not doing everything, he doesn't do the closings. That's a good thing. Don't use that as a negative. You don't want an all-inclusive. I did a deal in another state, same thing. We were moving it along. It was our normal closer. Excellent attorney. One of the best real estate attorneys I've worked with as far as like that stuff goes and title and finding it and working out stuff. But it came into an issue like this. And he was straight up, I don't deal with that because it takes extra time and I wouldn't be able to focus on that. And so he gave us a name and the two worked together and it got done. And so that's what you want to see in these cases. Don't be worried about bringing in extra people. Bring in the experts that help and will get things done, and that'll really be beneficial, for your business and getting deals done. So there are a few questions. We don't want to take too much time here, but I think they're pretty quick and easy for you. So you talked about trust. So a couple questions on trust that came up quick is somebody said, how do you know that you have the most recent version of a trust?
You don't really, but here's the question is that what's coming up on title? And what usually how a trust is titled on the deed, it could say like the Evelyn Smith trust dated December 3rd, 2009 as amended or if amended. And you know what? That's also up to title insurance, how they want to deal with that. That's the risk that they take is if there's something else. If nobody knows and everybody signs off that there's nothing else, then maybe that's all they can work with. But it's always a great question. That's called title insurance, right? Risk and money. They're taking the chance.
Okay. So then the other question that the same person asked regarding that was, what happens when it's in a trust, the law office that made the trust shut down and the heirs don't have a copy of the trust?
And that's where it gets expensive and complicated, because then there would need to be what they call a reestablishment and a recreation of the trust. And there are certain things we would need. And if we can't get it, then now we're talking dead deal. So one of the things would be an unexecuted Word version or PDF version of what that estate plan, that document was. And we would need affidavits of heirs from any potential intestate heir of that person that died, all of them. Like if there was 5 of them, like 9 of them, or 5 of them, 9 of them, whatever. We would need all affidavits of heirs. Basically, it takes a lot of work. I found twice that that's been done. And of course, what city did I find that in? Miami, right? Like that doesn't happen that often, because it's complicated. And those are the ones where you got to weigh, is it worth it or not?
Yeah, what I just got from that an answer, at least from the investor standpoint, is that's where you pick up the phone and call you or whoever, whichever state it's in, and say, this is the situation. This is my price. This is what the potential is. Is it even worth exploring? That's really what you got to do in every case, honestly. But some of them you just know without even making the phone call, right? Like I said, if it's a $500 deal and a $5,000 piece of property, it's not worth exploring. I can tell you right now, it's not worth it, because you're going to spend, by the time you're done with legal fees and closing, getting it done, you're going to walk away with nothing. So it's really not, it's not worth anything in that case. But in all those cases, that's where you've got to look at it and determine whether or not it's worth it or not from the financial aspect. Somebody also asked, when do you bring the probate attorney in? So a lot of what we teach is, you get a property contract, get a property under contract, you market the property, we have the right to market it, and then we get an end buyer that's ready. So if you understand that there's an issue, do you bring the probate attorney in and get the process started when they sign the contract, or wait until you're 100% sure that this deal is going to get done and you're going to have an end buyer ready to go?
I think it's at the get-go. I think if you hear somebody died, mom owned it, I think when you hear those words, or you think you had the right person and you send the contract to title and they say probate, I think when you hear the P word, right? When you hear the P word, or you hear death or died, that's where you should say, we need to get this evaluated and go see the attorney, right? I like that, because that way people are not spending time and money on a deal that was never going to happen in the first place. We can say, this is what we need. This is who you need. Get it locked in. Now we can do the probate. There's nothing wrong with getting under contract before the probate. Yeah, this gray area about, is it really enforceable and everything like that. But if you're worried about that with probate, you're not in the right game, because all of this is a puzzle trying to get to an end result. You just got to get what we need, but come to the lawyer in the beginning.
Okay, good. Somebody asked about the best way to find this land that's forgotten about. I mean, I can speak on it from the investor side, and that it's on the list. I mean, the land's may be forgotten about as far as who owns it. They may not know it, but it's still owned. It's still a record, or at least somebody's on record. So when we send out mail to these people, they're on it. They're on the list. So they may get it. We've had it over the years numerous times where people are like, I didn't even know my family owned this, or I didn't know, my husband bought this and I didn't even know he bought it. And then he died, and now it's like the wife's contacting us and things like that. So from the investor standpoint, it's still on the list. I mean, we're targeting people that are, just basically fit our criteria for land. If you're looking on a probate list specifically, that's going to be on there. If you're looking on a pre-probate list, it may be on there depending on, that's kind of a newer thing that's been coming out recently is pre-probate, based a lot on what I was talking about and what's coming up in the next decade to 15 years. So people are kind of taking advantage of that to begin with. But if you're getting a vacant land list, speaking just from the land investing side of things, those properties are on that list. I mean, so they'll be getting our any marketing that we send to them.
And you're talking about other list tax rolls, a property appraiser, you pull it. I mean, there's so many lead lists and things out there. Probates Daily has the pre-probates. That's what you're talking about, Jonathan, where there's never been a probate, but date of death was really recent. You'd be so surprised how you can easily find probate, pre-foreclosures, tax delinquencies. Why? Somebody had that property, they forgot to pay, they can't pay, they're dead. Huge opportunities there.
And then somebody asked about, maybe you talked about this. If you did, I missed it. It must have been just a quick point, but he said something about specific performance. I know what specific performance is, but I guess you may have brought it up. It says, do you usually find that a letter gets the seller to hold up to their end of the contract?
I'm not the type that does demand letters. So haven't seen it on my end. I've heard of people that try to do that. Again, when it comes to specific performance, it's all up to a judge and the equity about whether they would allow it or not. But it's really bad when like a deal I heard the other day where everybody was ready to close. They call it ready, willing, able, and able to consummate on the deal and close. And the buyer backed out, the seller backed out the day before. And so that looks really bad. And I mean, hey, people tried demand letters. I think lawsuits work better because you're serving them with something. I heard of something also really cool, doing a demand letter with a process server. I heard that was pretty interesting too. So haven't seen it myself.
Yeah, and I mean, again, just speaking from the investor standpoint there, I mean, I've personally sent just certified letters myself, threatening the next step. That works quite often. I mean, if you, and what I normally do is I'll copy the attorney so that they understand that, hey, the attorney's involved there. And then after that, like we have one right now, the attorney's sending them a letter basically saying, hey, we're taking this to the next level if you don't do that. And then at that point, again, it comes out to, is it worth it? I mean, I had one where it was a $600 sale, a purchase. It was like a $7,000 sale. The seller freaked out and started doing all this stuff. And I did all those first steps, but then it was like, well, am I really going to push this with specific performance for such a small deal, right? It's like, again, the cost of it. Do I want to force somebody? And again, I mean, you got to look at what their circumstances are. Are they just being difficult? Are they doing it because they're mad because you're making money? Are they just trying to break the contract? Or is there something legitimately there? I mean, I've had people that have ended their contracts halfway through on things that look good. And they're like, well, something came up in my family, somebody died and now we want to use this for this, or we want to sell it for this. And you just got to be a little human at that point and say, well, does it make sense to still follow through? So every circumstance is different. But personally, from the investor standpoint, I have found that just the threat probably works about 50% of the time. And then after that, for the other 50%, you're going to say, well, is it worth going down this road now? Am I willing to go down this legal road of getting the attorney involved, filing, like he said, you can file his pendants at that point, you're going to serve them, all of that stuff. Is it worth doing that?
I liked what you said.
All right, everybody. So I think that's it, Al. We want to thank you again. It was a great show here. It was a great kickoff to our Crushing Land series. Hopefully you guys learned a whole bunch more about probate. Al is in our group. So, if you're not in the group, if you're watching this on YouTube, there's a link in there. Join our Facebook group. I know a couple of people have actually made some comments. He's given a couple recommendations to attorneys in other states. We talked about that earlier because he knew somebody that handled this. He's handling pretty much everybody's deals in Florida that's in our group, just because obviously he knows what he's doing. And this is somebody that you'd like to work with if you're doing deals in Florida that this fits. Jamal talked about that already. He made a comment here in the group about how he's using them and things like that. And somebody else, like I mentioned, that went through our most recent training, just back in May was looking for somebody. Here we are in July. It's only been a couple of months, 7 airs, and it's done, right? So 2 months and it's done. We didn't really talk about that, but that was something that most people were saying was, everybody was basically saying 6 months to years. You asked about that earlier, and that is pretty normal. I mean, and the reason for that is because so many attorneys focus, like we talked about, on 18 different things, all under that real estate umbrella. Whereas here, he showed you his little list of these are the 5 things that I specialize in, and they're kind of under the same direction. So because of that, he's able to get them done quicker. So we'll make sure his information is in the description for this on YouTube and in Facebook. So you're able to reach out to him. Like I said, he's in the group, so you can just tag him if you have something, or direct message him or whatever as well. And again, I don't know if you're seeing it, probably not, because you probably don't have it open, but on Facebook, I'm watching hearts and thumbs up and everything going across the screen. So I think everybody was really happy. We look forward to doing this more, guys. Again, this was our first episode, so we're going to do more Crushing Land series. We have other people lined up, other professionals like this that you can use and that can give you tips on things that you can do in your business. So again, make sure you subscribe on YouTube. Make sure you keep joining our group here. If you haven't already, join the group so that you're up to date on all of this information. If you have questions on land investing itself, the training that we offer, being able to take it to the next level, feel free to reach out to us. You can send a DM through Facebook to Genus or Keely if you'd like. You can call us if you prefer. We'll put the number in the contacts as well, so you can feel free to reach out to us that way. So Al, I'll let you conclude for us. Any closing remarks that you want to say to everybody?
Jonathan, first, thank you so much for having me as the first episode of Crushing Land. I hope everybody took a ton of information and got a lot of value from it. I mean, probate is a great niche. Don't shy away from it. I'm so glad we got to talk a lot about these topics, especially when we got halfway through about the power of attorney and people thought dead deal. These deals can be possible. The money's got to be there, and the situation has to make a lot of sense. So just know that this niche, it's coming more and more. Don't shy away from it. There's a way to tackle it. Don't think about the misconceptions with timing. Probate can be quick. There could be an efficient way to do it. I love probate. I hope you all loved it too. And you can find me on all the social channels, the website, alnicoletti.com. And Jonathan, thank you so much again. I loved it.
Thank you again for joining us. It was great. Somebody just commented it was like drinking from a fire hose. The nice thing is, well, that's true. We're not pulling down these videos, guys. So it'll be on Facebook. It'll be on YouTube. It's going to stay there. So feel free to rewatch them, take notes, whatever you need. And obviously, what sinks in now is going to be different than what sinks in when you have that first contract in front of you and you're like, I've got this deal here that's $5,000 and it's worth $25,000, but it needs probate. What do I do? Well, that's perfect time to go back, review this, if it's in Florida, reach out to Al. If it's not in Florida, you can still ask in the group. He may know somebody, like we said, he did in Arizona, but if not, you can do a little research, yourself. And I guess that one last question that I'll throw out there just for people's advantage. I mean, if you're looking for somebody that specializes in probate, I mean, is that the question that you ask? You say you're in a state I don't know if it's or not, but let's say you're doing a deal in Indiana. Maybe you know an attorney there, maybe you don't. But if you don't, and you're looking around, what's the question that you ask the attorney? Is it, do you specialize just in probate, or I mean, how do you start that conversation to find you in that state?
I've gotten that question. How do we find you in another state? I don't exist in other states, but I think one of the first ways you can go is every state, every county, city should have like an investor association. So if you ever see an attorney there, that's probably a good first step because they're there because they're probably, who knows, investor friendly, or they have a way to do certain things in the real estate field. So that's a great first step. But the other way, if they're not, you can really get the sense that they do it. If they give you the, yeah, we do it. No. Like you like, tell me a little bit about how you structure it, right? Like somebody like Jamal asked, like, how do you do it? Like, I'm just like, this is what I'm looking for. I have a system. They reach out. I structured at the end. This is what my timeline is. I need these three people on board. There's a way to do it. There's a process. You will know by the confidence of how they speak about it. And plus, I mean, I don't know if they're probably not doing presentations, but I mean, there's a way to just know when you ask them. If you see how I am, all you got to do is look at them. Are they even close to that? That's a really good comparison.
Yeah. And obviously, I mean, you may be able to just ask the person you're working with as well, right? I mean, because if you're already doing deals there, the chances of a probate deal being your first deal, probably not huge, right? So you're most likely going to have a straight deal. So, I mean, ask your title company that you're using. You've already found an investor-friendly title company if you're an investor. So title company or an attorney, depending on the state. So ask that closing company, hey, who would you recommend for handling this? And if they tell you, if it's an attorney, that they do it, that's where you might pause a second, because like he just, now you're dealing with a closing company that's saying, because it's kind of like on those all-in-one attorneys. So you might be like, well, wait a minute, let me step back and look up a little bit better, because I'm not getting somebody that's just directly involved in probate. But if it's a title company, they're not going to do that because they're not an attorney. So they probably do have a name of somebody. So at least you can use relationships you already have to maybe find that person. But at least now, at minimum, watching this, you know what you should look for in those 49 other states. And for everybody that's doing deals in Florida, most of you, I think, are, or at least have dabbled in it. It seems the state that everybody likes to at least try for some reason. Then, you now have somebody that, you can work with yourself when you run into these issues. All right. So we thank you again, everybody. We thank you for joining us. This will be out there. Again, it'll stay on YouTube. It'll stay on Facebook. Make sure you join our group. If you're watching on YouTube, make sure you subscribe to the YouTube channel. If you're watching on Facebook, it will be a clearer video a little bit. Should be a little clearer and easier to watch on YouTube. So again, thank you all. It's a great premiere episode of Crushing Land. We once again thank Al, and we'll keep you posted on future episodes. If you have any questions on probate in Florida, reach out to Al. If you have questions on investing with, I shouldn't say that. He is an attorney, and he does, there is a charge for working with him just like anybody else. So if you have a general question, you could ask it in the group and he can chime in. If you have a specific deal in Florida to work with, and they reach out to Al, don't bombard him with crazy questions. He was generous enough to come here for an hour and a half today and basically go through it. So, but if you have something that fits now, reach out to him. If you have stuff that's general to land investing, feel free to post it in the group and reach out to us directly and just take your business to the next level. So again, thank you all for joining us. Thank you, Al, for being here, our first guest. We had a wonderful time, and we'll catch you guys all another time. See ya.